I'm Ari Redbord, and this is TRM Talks. I am Global Head of Policy at TRM Labs. At TRM, we provide blockchain intelligence software to support law enforcement investigations and to help financial institutions and cryptocurrency businesses mitigate financial crime risk within the emerging digital asset economy. Prior to joining TRM, I spent 15 years in the U.S. federal government, first as a prosecutor at the Department of Justice, and then as a Treasury Department official, where I worked to safeguard the financial system against terrorist financiers, weapons of mass destruction proliferators, drug kingpins, and other rogue actors. On TRM Talks, I sit down with business leaders, policymakers, investigators, and friends from across the crypto ecosystem who are working to build a safer financial system. Today, I am joined by crypto lawyer Matt McGuire. But first, inside the lab. Recently, the U.S. Treasury Department's Office of Foreign Assets Control, OFAC, used sanctions to target the human trafficking networks related to forced labor in online scam centers. Specifically, OFAC sanctioned Cambodian businessman Lee Young Fat, his companies, and Osmak Resort for their role in the pig butchering scourge that has devastated countless victims of scams and human trafficking. It often goes unrealized, but the frontline scammers in cryptocurrency-related frauds are often themselves victims of human trafficking, including forced labor, and are subjected to physical and mental abuse. According to TRM Labs, scams and frauds totaled about $12.5 billion last year, accounting for approximately a third of all crypto-related crime. Pig butchering alone accounted for about $4.4 billion in 2023. But with the focus on the victims of the scams themselves, we often lose sight that there are millions of people affected by the trafficking aspect of these crimes. For more than 2 years, according to Treasury, Osmak Resort has been investigated by police and publicly reported on for serious human rights abuses. Victims reported being lured to the resort with false employment opportunities, having their phones and passports confiscated upon arrival, and being forced to work scam operations. People who called for help reported being beaten, abused with electric shocks, made to pay a hefty ransom, or threatened with being sold to other online scam gangs. There have been 2 reports of victims jumping to their death from buildings within the resort. I spent about 2 years at the U.S. Treasury Department working closely with teams from OFAC, and I can say that OFAC and Treasury and so many others in the U.S. government are focused on how can we use these authorities to go after bad actors, to punish and change behavior. This is a great example of OFAC using their authorities to go after bad actors to stop horrible human rights abuses. Now, I sit down with Matt McGuire. Welcome to TRM Talks. Today, I am joined by friend and Arktouros partner, Matt McGuire, one of the really foremost lawyers and thought leaders in the space. Matt, thank you so much for joining TRM Talks.
No, thanks so much for having me, Ari. It's a privilege to be here. I'm excited for the conversation.
Tell me about your journey before we sort of really dig into sort of the pressing legal issues of the day.
For sure, happy to. I've had kind of a winding road. I get teased a little bit by a friend of mine, Judge Heitens, on the Fourth Circuit, that he couldn't make sense of my career for a little while, but it's come full swing. I was lucky enough to actually, I'll just say, I met my wife in undergrad and made a lot of decisions from there based on her. And so we ended up in D.C. to go to law school. I went to George Mason, had a wonderful experience. I was sort of the first person in my family to go to law school. So I made all of this up on the fly. I had no real idea what it meant to be a lawyer, what the career path looked like, what you could do. But in law school, everyone says you should clerk. And so I certainly took that to heart and wound up working for an amazing judge in Jackson, Mississippi, of all places where I have no ties. Judge Jolly for a year on the Fifth Circuit, came back, spent a couple of years at Jones Day in D.C., where I've made some amazing friends and connections, and really exposed me to the world of appellate work. So I was an appellate lawyer very early in my career, and that's sort of when I started to find this love of the law. And at Jones Day, they hire a million amazing, talented Supreme Court clerks, so it was difficult to get some of the work. And my wife and I really wanted to live in Richmond, which is where I'm from. So we're like, all right, how do we make that happen? Mark Herring, the Virginia Attorney General, was expanding Virginia Solicitor General's division at the time. And you now see a lot of folks go into attorney general's offices and they have very active solicitor general divisions doing appellate work and high stakes litigation. It's relatively new when I did it. I think I was the first person I knew to go take a job like this. It was awesome. I spent 4 years in the AG's office, ended as the principal deputy solicitor general and like executive division counsel, argued a case in the US Supreme Court, like 20 other appeals. Just he gave me remarkable experience, and I'll always be thankful for it.
Amazing. Tell me about the Supreme Court case. I mean, that is just one of those extraordinary life experiences that I feel like you had very early.
Yeah, it was amazing. I was 31 years old. We actually had two at the same time for the Virginia SG office, and there were only two of us in it. So the current Solicitor General was like, I'll take one, you can have one. And a really fun anecdote, they came out of the same circuit court judge in Charlottesville, Virginia, handled both of those cases that wound up in the US Supreme Court in the same term, which I don't know has ever happened. My case had a really cool fact pattern. It was about a group of friends who allegedly stole a safe full of guns and money and then took all the money out of the safe and threw the safe in the river. The problem for them was they were felons previously, and they got charged as a felon in possession of a firearm despite chucking the guns in the river because they touched them as part of that process. And the issue in the case was, well, you want to split those charges because to actually convict somebody a felon in possession, you have to tell the jury they're a felon, which is super prejudicial, as we all know, to criminal defendants. So they did that, and then he was acquitted at the first trial for stealing the safe. And the question to the U.S. Supreme Court was, does that count for double jeopardy? If you agree to split your charges that way and you get acquitted at the first trial, can the state prosecute you at the second?
Gosh, there's so many interesting analogies. You think about, I'm a big baseball guy, and you think about sort of the transfer, like what it requires to have possession of the baseball, right? Like to actually record an out or something like that. I feel like the guns were passing through these guys as opposed to like possession in the true sense of the word. Wow, what a really cool case.
Yeah, and it was just, it comes out of a whole double jeopardy doctrine that the U.S. Supreme Court essentially made up in the 1970s. It's not really tethered to the constitutional text. It was, people might be familiar with Ash versus Swanson, which is a case where poker players got robbed. A guy broke in and there were six people playing poker, and then he robbed all six of them. And the state originally tried to try him for one of the robberies, for one of the poker players. They lost that case. So then they proceeded to try him again for robbing a different poker player. And the Supreme Court said, well, you can't just try people seriatim on the same set of facts. That violates the double jeopardy clause.
Really interesting.
And so that was the idea here is you couldn't retry this guy because you've already said he didn't possess. The jury would have had to have found he didn't steal the safe, so he could have never possessed the guns in the safe. So that issue of ultimate fact has to be conclusive.
Amazing. So how does a state solicitor general and a Supreme Court advocate end up at Shopify and then ultimately into the crypto space?
Yeah, so it was the middle of the pandemic. I was spending some time at Hunt and Andrews Kurth, where I still have some amazing friends. And I was at home. I was actually in the same place I am now recording this. And Shopify posted a role that struck me as too good to believe. It was, we've never had a regulatory lawyer. We want somebody to come build out our whole regulatory program for all governments sort of in the world. And I am a big e-commerce person. Despite being a privacy lawyer, I actually personally like targeted ads because it shows me all kinds of cool stuff I can buy. And I was familiar with Shopify as kind of the backbone for all of those things you see for a lot of small businesses. And as somebody who comes from a small town, I care deeply about trying to rehabilitate main streets and like letting people stay where they are and do cool global transactions. It was super appealing. And I also tended to think a lot of companies get government interactions wrong. They're unnecessarily adversarial at times, or they don't quite pick up on exactly what the risk is that they're facing from the government. And it was a chance to write on a blank slate at Shopify.
Really extraordinary. And then ultimately you make this really interesting leap from really the most important company in the e-commerce space or one of a very few to essentially a tiny startup in a nascent industry where there's absolutely no clarity on any issue. And I feel like you just dove in head first with the kind of thoughtful response you just gave about Shopify, like about everything. Like, but what caused that?
Yeah, so I saw a little bit of it at Shopify. Everyone was sort of interested in Web3 and crypto. And then I'm a video game sort of computer guy in my spare time. So I've always been interested in it on the margins, sort of curious about how all these things work. And I like really hard legal problems and cutting edge legal problems. And you could sort of see it coming in the Web3 crypto space. But like the biggest draw for me, candidly, is I'm a huge jurisdiction nerd. And as soon as you put something and the whole business model is online, you've broken almost every legal rule in the world. There's no country that's really capable of understanding how the internet affects their actual authority. And so that makes every issue that comes up global and inherently just fascinating.
It is a really interesting way to put it. I think people try to figure out all the time, like, why is there not clarity or why do we struggle with some of the issues in this space? And it does, in many respects, come down to jurisdiction. Let's kind of dig in. I mean, what are the top legal issues for you today in this space?
Yeah, I mean, I think in some sense you actually have to split it into sort of what the public perceives as sort of the major issues, which is obviously CFTC, SEC, side of the core financial, I would call them civil regulatory schemes, because they just disrupt so many people's business practices. And we're seeing so many enforcement actions in the space. So I think from an immediate public facing perception, that is the most important issue. I do default typically on the jurisdictional side and sort of in a less aggressively public way on the sanctions kind of piece. Sort of for jurisdiction, I think it's just really important to understand where your exposures are because all the laws are a little bit different everywhere. And if you're not in the US or you want to functionally block the US, you can solve that SEC, CFTC problem. But if you don't really map, number one, like where's your corporate entity, but also two, where are your employees? Where do you do marketing? Where are you trying to have users? Where is the hotspot for most of your users? You don't fully understand what the risks you're taking are. And they can show up in really weird ways, especially if you don't provide good contact information for the government or somebody who's interested to reach you. Like that really becomes a problem very quickly. And then sort of on the sanctions side, with Tornado Cash and the other way things have been added to the SDN list, and just the way we all know sanctions regulators to think about it, plus the criminal aspects. It's something everyone really has to take seriously and try to get right. And it's a nuanced topic. So I just think that's the piece that affects everyone because it's not limited to just financial services industry, right? I mean, what's been interesting to me in crypto is how much we talk about financial services regulations. But actually, all of the regulations in the world that apply to all the companies will show up in crypto someday. And sanctions, we talked about it at Shopify. It affects everyone if you're sort of involved in the stream of commerce in any way.
On the CFTC, SEC thing, I think that obviously every day we get a different take on that. But what's your take sort of overall? I think I was hearing a little bit of like, look, this is going to be something that'll be resolved. But talk me through that. Like, how does Matt McGuire, partner at Arktouros, today advise clients? Give us a quick take on is it a security? Is it a commodity issue?
Well, I mean, I think they're all commodities, right, in some sense. And then you have to answer the securities law question under Howie. I mean, I'll frame Howie a bit because this is kind of how I do talk about it with people because we don't have clarity right now. And for all the district court decisions that are going around, like the appellate lawyer in me just sort of howls all the time that, well, once the Second Circuit or the Fifth Circuit or pick one actually addresses these issues, we might have some clarity because that's a precedential decision that will really take it at a more abstract level of law than what you get from a district court, where they really care about developing the facts or they really are focused on what's happening in that case. The appellate courts will take a broader view. And sort of my view of Howie has been set aside the actual test for a moment and look at sort of the pedigree of that case and look at what the U.S. Supreme Court has been willing to do recently. They're very open to revisiting old cases, especially if they're not doctrinally sound. And Howie comes out of the 1930s. It's reinterpreted a couple of times in the 1970s. And absolutely nowhere in the decision do any of the appellate courts or the Supreme Courts grapple with why is that four-factor test textually sound under the relevant acts. They sort of say this is what investment contract meant in the 30s. That's what we're going to say it means now. And so this is the four-factor test. But it's not sort of a textualist interpretation. As Justice Kagan would say nowadays in statutory interpretation, all of us are textualists. So that doesn't mean that I think Howie gets overruled. I suspect that won't happen and there's too much reliance. But it's a really good argument for an appellate court to say we're not going to extend it. Like we're not going to keep reaching out in the world to like the Pokemon cards or the open sea issues that are going. Howie stands for what it stands for. It applies in the core securities law context.
And just for like listeners, look, I mean, the issue is, does a case from the 1930s involving an investment in orange groves, where the court ultimately found that because they were relying on a third-party promoter for profits, you had an investment contract, which essentially made them securities, applies to this world of cross-border value transfer at the speed of the internet and digital assets. You mentioned OpenSea, and that's a really interesting one and sort of like breaking news over the last couple of weeks. I was a little taken back by that one. It felt a little different. Did you have that feeling, or are you just so deep in it that like it's all crazy?
No, it certainly seemed like a whole new step to me because so much of what would move across sort of a secondary marketplace like OpenSea might be genuine art. I mean, I own some NFTs just because they're art. Like I have no idea if they'll go up in value. I just think they're neat. And like that can't be a securities transaction.
We have this amazing designer who was a super early employee of TRM, and she's done some really cool graphic design for me for different like TRM blog posts and cool stuff. And over the years, I've minted them on OpenSea and like sent them to her as like a thank you for, having done like this just really cool, fun graphics. I'm minting NFTs on OpenSea, and just the thought of that, because I agree with you. But there's a whole other segment. Is that the argument on OpenSea that isn't one-off art per se, but it's series, or is that, the sort of Bored Ape idea? Is that where ultimately the arguments are going to be headed? And I know this is only a notice, we're not sort of beyond that, but what are your thoughts there?
Yeah, I mean, it's so opaque just given what little we currently know. So, I mean, we'll have to see the complaint. I assume that is where it's going to head. It's going to try to identify certain types of NFT sales on the secondary marketplace where the NFT sale constitutes an investment contract. I mean, I think one of the big meta parts that's so problematic about this is we're not saying the NFT or the tokens are securities. We're saying the transactions in them might constitute investment contracts. And I don't know how you actually ever have clarity as a business around which transactions that randomly happen on your platform are permitted or not. Because you're not saying the thing is, you're saying this particular set of facts surrounding that particular sale is. So you can't build a business that way. And like that also suggests to me it's wrong. But I do think it'll go in the direction of sort of the Bored Apes, this kind of that people are speculating on them, and so they're investments because people are speculating on them. But even a lot of those NFTs provide you sort of club membership benefits in different ways. Like there's all kinds of use cases around this.
Sure, and you collect them and you show them, maybe even display them in some way if you can figure that out. One thing that strikes me about that answer is like, it's probably why it's more important than to have lawyers with true subject matter expertise in this space. In particular, you just joined Arktouros, which is a relatively new law firm with really extraordinary lawyers like Michael Mosier and Jane Kardasky. Tell me about that move and like what you guys are building there.
I love Arktouros. They couldn't be a much nicer or smart group of people. I mean, Michelle Gitlitz is an expert on money transmission. You have Michael Mosier, all the sanctions folks with Clay and Mike Parker. I mean, it's just an amazing, amazing group. And I was looking around for what I kind of was feeling out what I wanted to do next. And the opportunity to go to a place that has genuine subject matter expertise that's really steeped in emerging tech, kind of in and out of the blockchain space, gives you this window to address the hardest issues, right? Because I do think you need subject matter expertise when you come to the technology. Like on the law, like a lot of really smart lawyers can sort of pick up different aspects of it. I'm a generalist at heart. Like I wasn't a financial services person before I got into this. So you can kind of figure out the law and kind of work through it. But the actual ability to understand the technology, right? That's how you give really great client advice. That's how if you go to court and litigate like I like to, that's how you explain it in real layman's terms to a judge, is that you have to really understand the technology. And I think that's what Arktouros and firms like it can bring is like, we really understand what you're building. We understand technically how it works. So then you can properly identify the issues.
Absolutely. One of the issues that we've really dug into, and I think you started to get there a moment ago, was this issue of sanctions. But I think sanctions really sparked a conversation that goes way beyond sanctions. And that is essentially, how should regulators or even law enforcement globally thread that needle between ensuring that lawful users have access to technology, but at the same time, stop bad actors?
Well, it's why I got into space. I mean, honestly, DeFi Labs set out on this mission to sort of how can you have the equivalent up to traditional financial level compliance without destroying everyone's pseudonymity on chain, right? I mean, I think blockchains make this really super hard because they are so inherently public. And so if you get the compliance wrong, you have permanently ruined somebody's financial privacy forever, right? I mean, I think the privacy risks here are immense all the time across the board. I really think it's solvable, though. I mean, in a practical set of terms, I think you can get partnerships among the groups that are currently doing KYC or other sort of know your customer information screening to share data more, right? I mean, the Bank Secrecy Act allows for you to sort of rely on other compliance programs, even though historically a lot of folks don't. But that to me is the big solve. Like the 10,000 foot view is you have to stop hemorrhaging your data all over the internet to everybody all of the time, whether it's for compliance or because you want to buy something and they need to ship it to you. because we're all inundated constantly with my data has been breached by pick a place. And like it's a near constant problem. And I think where crypto can really help advance regulatory policy is showing, well, actually, the way this is so interoperable, you don't need everyone to do the compliance. You need some subset of like trusted providers that really do this for people, right? Because everyone talks about the range from like, here's a trusted intermediary that holds the data that could answer lawful government requests, all the way down to zero knowledge proof self sovereign data usage. I'm actually a big believer in both if you really work with the government and really explain what you mean. Because to me, the issue is always government access at the end of the day. You want your privacy, you don't want people to know who you are. That's all fair. But there are moments because of we live in a civilized society with sovereign nations and they have laws that allow them access to your data in certain circumstances. And as long as you can meet those requirements and build that into your system, you should then be able to go back to the regulatory community and say, you're getting all of the same information you would have gotten if 55 places held Matt McGuire's data. But instead, there's one place and they're specialists in it and they know how to work with you and they know what the rules are. And so they're going to be able to satisfy all of your requests. And like, I actually have taken a lot of grief for this from some folks, but like, I'm not a big believer in the risk-based approach to compliance. I think there's basically one subset of risks in crypto. You could have a standard on what compliance looks like, and everyone aims for that standard. And you have all this public blockchain data through the amazing work TRM does to sort of say like, and this is kind of how it works. And we can all agree on that. Somebody knows who's behind that wallet. And if you have a legitimate question, go to them.
It's interesting. I mean, we do have some practical examples of this. One, I'm sure you're having, pretty nascent businesses come to you and say, hey, how should we think about this sort of from day one, which is exactly the right approach, right? You go to Matt, you ask these types of questions. A lot are obviously not doing that. But then you also have Tornado Cash, which I don't think is useful for as an example of everything. But really it is like, there were a lot of lawful users who were using that service. But at the same time, North Korea was using it at scale to launder billions of dollars to fund weapons proliferation and to destabilize the Korean Peninsula. Like, that's not going to stand. So the question is, how should we think about advising businesses in this space?
Yeah, I mean, to me, you always have to separate the front end from the smart contracts themselves, which is a big part of the advice I give is like, if you run a front end, you are responsible for that. That's clearly what everyone's focused on is the front end. I think one of the untapped questions is what do you need to do on chain? What do you actually need to embed in smart contracts? Since we all know the really sophisticated actors, or according to my engineers, even not super sophisticated actors, can call smart contracts directly in the command line if they know what they're doing. They don't need to use your front end. Do you have to bake sanctions compliance in on chain? That I find to be a way harder question around how do we resolve it. And there is something to be said about the on and off ramps to crypto and fiat being like really the right spot to catch that particular group, right? Because we should really hone in on exchanges and sort of the transition points back to fiat economies and say like, look, there's zero tolerance here. In terms of on-chain, you need to take care of your front ends if you're providing these direct and easy access points to regular consumers. But you can't stop all bad actors, as we both sort of know. I mean, it's sort of a sliding scale of like what is prudent and reasonable to do under the circumstances.
Yeah, it's really well said. I mean, I think something most people don't know, and I get this all the time, is that we were providing sanction screening and some anti-money laundering for DeFi services before sanctions against Tornado Cash, to include Uniswap, which there was all kinds of issues around at the time, but it's absolutely doable. I think the challenge, to your point, is that you could go around those controls to the protocol where compliance isn't being done today. And I think that's the challenge. It's going to have to be a combination of both. What are clients asking, and what else is really top of mind for you in this space?
So it really is the data protection concerns, because I think right now the industry and sort of from the regulators that are interested is this push to take in ever more consumer data and user data to sort of do the compliance tools. But we haven't heard a lot in the world from the actual data protection regulators. And I think there is real tension in this for companies, right? Because number one, if you haven't built your project to take in user data, you don't have all those security protocols in place. Like you're actually building a subset of what I think is extremely sensitive data. It's why I give that sliding scale analogy on like smart contracts around with sanctions is as soon as you take a wallet address and you store it in your system with somebody's personal information, like that is a very sensitive set of documents. right? Because once that gets out and anyone moves funds from the wallet that's compromised, you can trace that. And it's very hard to ever regain your privacy. Or some of the cool solutions in the compliance and identity space that want to do on-chain attestations or sort of store any kind of data on chain. Like you have to be very, very thoughtful around, does this trip up any of these privacy laws? How do you square it with, say, the right to deletion under GDPR because it's immutable? And so unless you have built the thing in a way where you actually can scrub it, you may have committed a sort of permanent violation. And I don't think we have any clarity or really any analysis yet in that space, but it's coming.
What would it be useful to, clients, industry folks that you're having conversations with from a sort of policy or legislative perspective?
Yeah, I mean, I think you could get real helpful guidance from the data protection regulators to say, we actually don't want you to ever store user information with wallet addresses, right? Because then you sort of end up with regulators needing to talk to each other at that point, because it's like, well, on the financial crime side, we need this. But on the data protection side, we realize just how incredibly sensitive that is. So you sort of force the issue that way. Or guidance around just what wallet addresses are. Like how much personal information do you have to put next to a wallet address where you've now converted the public key to a piece of personal data itself, right? Because I think that's something we all worry about because you certainly don't want them to be viewed as personal data. So those types of issues. And then overall, it kind of feeds back, at least from a US perspective, right? The FTC is both the privacy regulator in a sense, but also the consumer protection regulator. And at least for me, the great hope is we're about to see a wave of consumer applications and real use cases sort of built on crypto rails. And the day that happens, all of the consumer protection regulators, from the state attorneys generals back to the FTC to all of the global ones, they will care because real people will make mistakes. They will get hurt. And that's how you get consumer protection liability.
Absolutely. Well said. When you're sort of thinking through, obviously, I think for better or worse, the issues that we've talked about today are going to be the issues for some time because they're hard. But are there issues that you sort of foresee? I think one point you made, which was a great one, and I think you and I both believe very much, is in the consumer application. Hopefully that's the next step here where we see more use cases. We see people engaging with technology on a day-to-day basis.
Yeah, so I really am keyed in on the consumer protection side. It's a space I know quite well, and I do think will come in a hurry. And it's sort of looking at how do companies even think about testimonials and reviews about their product, right? The FTC just put out a rulemaking that's more targeted at the e-commerce space, but it applies to just reviews in general. So how are you trying to tell people what you're doing is the best and they should come use you? I mean, it's thinking through how to advise clients on think about this stuff early. So before suddenly you do have real retail users or consumers are arriving at your system, and now, oh, they messed something up. Now this is a problem. And then you'll get immediate questions, right? I mean, you know this, but I think it is important to realize a lot of your risk just comes from bad things happening to people and they then go complain about it. I mean, it takes one person to call a state attorney general's office hotline and say, hey, I lost money because this system didn't work, for them to call you. And now they have you in a file and now they'll try to figure out what you are. And the problem in the greatness about our industry is it's really new. And they don't understand it. And then you're going to get a lot of questions from sort of folks who don't really understand how this works. So there's also an educational component that I think ought to take place with a lot more going into the consumer protection side of the government to explain the benefits of crypto rails, how this really works, and how you're thinking about, protecting consumers or ensuring at least the system works the way it's intended.
Moving back a little bit to kind of what you're doing now, I feel like what you guys are doing at Arktouros, it's like putting together a group of friends, maybe former colleagues who have a distinct subject matter expertise. A, is that right? And then kind of B, who are your clients? Who's coming to you for these conversations today? And how should we think about that?
Yeah, so it's absolutely right. I mean, it is a group of friends and genuine subject matter experts.
I totally love that. Matt, thank you so much for joining TRM Talks. I'm excited to do it again.
Thanks so much, Ari, and TRM is the best.
It's really interesting. We have discussed myriad legal issues over the years on TRM Talks, and this would be lost on a lot of folks, but I've never had a lawyer on one-on-one where we just went through really the key legal issues of the day. I felt a little like a client building a crypto business today, building a DeFi protocol, saying, hey, what are the issues that are top of mind that I really need to know? And that's really exactly who Matt is in the space. He's a lawyer's lawyer who really, really understands the technology and the legal issues around it. So if you're a builder, if you're a developer, you go to him and you really ask these questions. And hopefully we asked some of those key questions today. I also loved hearing about Matt's journey. My favorite part is this idea of sort of, he was a Supreme Court advocate arguing, this felon in possession case. So oftentimes we'll have technologists, we'll have law enforcement, we'll have policymakers on, but we are literally developing jurisprudence as we speak in this space. And great lawyers like Matt and Michael Mosier and Rebecca Reddig and that team at Arktouros are really doing so much of that. So very, very cool to have him on. On the next TRM Talks, I sit down with Ellen Feingold, the Smithsonian's expert on the history and study of money. We will discuss how crypto fits into the study of numismatics and have a very big announcement. Join us. If you love the show, leave a review wherever you're listening to it, and follow us on LinkedIn to get the latest news on crypto regulation, compliance, and investigations.
TRM Talks is brought to you by TRM Labs, the leading provider of blockchain intelligence and anti-money laundering software. This episode was produced in partnership with Voltage Productions. The music for this show was provided by Ecolix.
Now, let's get back to building.